Hello and welcome to Healthcare Matters, the internet television program that explores the intersection of medicine and the law. I'm your host, Mike Matre, and today's guest is Richard Rymond. Richard is an attorney at the Reminger law firm in Cleveland, Ohio, where he is focused in medical and dental malpractice liability, commercial liability, professional liability, general liability, and product liability defense litigation. Welcome to Healthcare Matters, Richard.
Thank you. Thanks for having me.
Today we're going to discuss how to respond when facing a medical liability claim and receive a records request. Could you walk us through how to initially respond when facing a records request?
So most importantly, when a physician receives a request for records, the physician needs to respond to that request. Typically, the request will be for a complete copy of the chart, and that's what should be provided.
Now, when facing a records request, is there anything specific that the healthcare provider should not do?
Well, the most important bit of advice that we can give is don't panic. There may be a temptation for the physician to review the chart to make sure it's complete, that everything that ought to be in the chart is in the chart, and the physician might, in reviewing the chart, decide, gee, I should have added this, or I should have added that, or this shouldn't be in there, or that shouldn't be in there. Any change that the physician makes to the chart before producing it may expose the physician to a claim for spoliation of evidence. That can give rise to a claim for punitive damages. It can also jeopardize insurance coverage in some circumstances. So the physician should promptly, courteously, professionally respond to the request and produce exactly what is requested.
Okay, that's one thing that a physician shouldn't do. Are there any other specific things that a healthcare provider should not do when faced with a records request?
Sure. The healthcare provider should not ignore the request. A prompt response, a courteous response, and a complete response is in order. If the physician ignores the request, or if his response is perceived as being too slow, that could give rise to a higher index of suspicion concerning the underlying care.
Is there any difference in response if the record request comes from a third party, another healthcare provider, or a lawyer?
The only consideration here is whether the physician has received an appropriate HIPAA-compliant authorization signed by the patient. If the patient requests the records, the patient is entitled to the records. If a representative of the patient requests the records along with the requisite HIPAA-compliant authorization, the records should be produced. A word of caution here, though, at least in Ohio, we've seen a situation where the physician receives a subpoena for records. The physician believes that, gee, they have to respond. This is a subpoena. It has a legal authority. In point of fact, absent an authorization signed by the patient or absent an order signed by a judge, which is different from a subpoena in most instances, the physician should withhold producing the records. When in doubt, contact your insurance company representative, contact your lawyer.
Let's say that the patient and his or her attorney request the original records. Should the physician receiving the request send those original records?
Well, we never recommend producing the original records. Once the original records are produced, of course, the physician no longer has control over them, and somebody else may inadvertently make a change to them, write something in the margin, misplace them. For that reason, we always recommend producing a copy of the chart rather than an original. Sometimes the original chart contains information which is color-coded. A lot of physicians, for example, with missed or broken appointments will write that in red if it's a handwritten chart. And I think some of the computer systems, the electronic records, will do the same. In instances where there's any color coding to a chart or colors have significance, we would recommend producing a color copy of the chart.
Prior to turning over those records, should the physician review them prior to executing the request?
So my view is that they should. By the way, I should have perhaps mentioned it earlier. There may be a temptation on the part of the physician who receives the records to reach out to the person who's requested the records or reach out to another healthcare provider who they know is involved in the patient's care. They shouldn't do that. They should, however, review the records to make sure they're complete. Sometimes records, for whatever reason, may contain things that don't belong in the records, perhaps a note from another patient's chart or some other patient identifying information simply because it was misfiled. Sometimes when there's a request for records, it's because the patient has experienced some sort of complication associated with their care. In those instances, the physician may have consulted with an attorney or may have consulted with their professional liability insurance carrier. And there may be notes concerning those consultations in the chart. Those should not be produced. Those are privileged. And if they are inadvertently produced, that can actually result in a waiver of the privilege, which we never want to see. Again, when in doubt, talk to your attorney, talk to your insurance company.
Let's say a physician receives a request for records. Is it beneficial or even permissible for the physician to reach out to his or her colleagues who may also treat the patient in an attempt to figure out what initiated the request?
The short answer is no. Typically, when there's a record request, it's at the conclusion of any care that may be involved. So frequently, physicians will have authorization from patients to consult with other healthcare providers. But typically that is for the singular purpose of providing health care. Once the care is concluded, there is no legitimate reason to consult with other healthcare providers, and that in and of itself may be deemed a HIPAA violation.
Okay, we've talked about how this is really the patient's records, but let's say the patient is in arrears or hasn't paid for medical services. Is it still the patient's right to see their records if they request it?
There actually are some professional advisory opinions on the subject, and while the temptation might be to withhold producing records until the patient account is paid, that should not be done. The patient is entitled to their records. There is an independent question of whether the healthcare provider can charge a fee for copying of records. I've probably seen it 100 times in my practice where the healthcare provider tries to dissuade the requester from following up on the request by charging a substantial fee, $200 for a 5-page chart, for example. Most states, certainly Ohio, has a statute which limits what can be charged for the duplication of a chart. And while the healthcare provider may want to get prepayment for the duplication of the chart, there are risk management considerations that might dictate against making that request.
The United States healthcare system has spent the last several years migrating from paper records to electronic medical records. Is there a difference between how one should treat an electronic medical record as opposed to the traditional paper record?
Well, there's absolutely no difference. When a patient requests the complete chart, the patient is entitled to the complete chart, no matter what form it's in, whether it's a handwritten health history form that appears in a paper chart, an electronic health history form that appears in a digital chart, the patient is entitled to the complete chart. Sometimes I know with some of the electronic record systems, there's different buttons that can be pushed that might result in a different printout of what's being produced. And the short answer, though, is that everything needs to be produced. When in doubt, again, consult with your attorney, consult with your insurance carrier.
As an attorney who's handled many medical liability allegations, what is the one thing you would stress regarding how to handle a records request?
That's an easy question, and we covered it previously, but it bears repeating. Never, ever, ever change the record in any manner whatsoever before producing it in response to a request for your records. That means don't make an alteration, even though it is intended to clarify, even though it's being made in good faith. Just don't do it. It exposes the physician to new and independent claims that may have nothing to do with the quality of the care provided.
Well, thank you for coming on Healthcare Matters, Richard. It's been a fantastic discussion. Thank you.
Thank you for having me.